Hello, I'm David Roger, General Counsel for Las Vegas Police Protective Association. This is part 2 of a video concerning a recent case, Scott versus Smith, a 2024 case in which Scott was being detained to do a legal 2000. He was handcuffed and died, and officers were sued in federal court. And the Ninth Circuit Court of Appeals held that the officers were not entitled to qualified immunity. And there was a previous case, Drummond versus Anaheim PD, which was somewhat similar. And so, the court said, based upon the facts that the court was presented with in order to make this legal decision, officers handcuffed an individual, had him on his stomach, placed their knee on his neck and back, and he expired. And so they went through the Graham versus Connor analysis. In the previous video, we talked about segmenting and compression, asphyxia. But as part of the Graham versus Connor analysis, the court looked at the severity of the crime and doing a balancing test to determine whether use of force was reasonable under the circumstances. This is a position that I've talked about in the past. It's my opinion, but I think it's something that departments have to consider, and certainly you as officers should always keep in mind because it's important. We're talking about your legal protection and whether you're going to be sued as a result of doing what you believe is the right thing and whether you'll have qualified immunity. And so the question is, when you go on a legal 2000, the person is not a threat to others, maybe a threat to themselves, but maybe not, do you even go to these situations? And so in Scott versus Smith, Scott actually called police and said that, he's hallucinating. They go to his apartment. He won't open the door. They continue to knock. They don't have exigent circumstances to go into the apartment. They stay there. He finally comes out. He's got a pipe and a knife. He drops both the pipe and the knife, and then officers decide that they needed to restrain him in order to do the legal 2000. And when the court is looking at Graham versus Connor, the court is trying to decide, what is the severity of the crime? What crime did the person commit? And in this case, they said that the person did not commit a crime. He was not a threat to himself or others. And the court concluded, in sum, because Scott was mentally ill, was not suspected of a crime, and did not present a risk to officers or others, the government's interest in applying force was limited. And so this is a 2024 case. This is the Ninth Circuit Court of Appeals telling officers, when you're dealing with mentally ill people, is it necessary to use force? And my question to you is it even necessary to go to the call? I'm not a cold-hearted individual. I don't think anybody wants to see someone commit suicide or harm themselves. But my concern is for you. My job is to make sure that you are legally protected, that your family is legally protected. And so I hope that you'll discuss and give some thought to whether you should even go to these calls. These officers went above and beyond the call of duty. Once the guy didn't answer the door, you know that there's nobody else inside the apartment. Do you continue to hold, hoping that the person will step outside? We go on, people calls on where people are threatening to commit suicide. They're home alone in a house. It's sad, but how many times does an officer's good deeds turn into use of deadly force because we turn a situation into suicide by cop, and officers have to use deadly force to protect themselves or other officers or bystanders. And so, the courts aren't going to back you on this. And so why even go down this path? And I want to share this final thought with you because it's somewhat comical. The court, in talking about the use of force and balancing it against the severity of the crime, said this: finally, construing the facts in favor of plaintiffs Smith and Huntsman, ignored less intrusive alternatives to the force they employed. Plaintiffs' expert opined that Smith and Huntsman had alternatives to body weight force. They could have used verbal de-escalation strategies, something the department teaches, waited for the support of additional officers to execute a safer, quote, team takedown, unquote, or, listen carefully this one, or waited for EMS to execute a soft restraint, quote, unquote. How often are paramedics going to tell you, hey, step aside, we've got this one, we're going to put soft restraints on this individual? It doesn't happen, but that's the la-la land that some judges live in. So at the end of the day, I ask you to talk in briefing, talk to your squad mates, and hopefully departments, big picture, will take a look at this as well. Is it necessary for armed police officers to respond to situations where a person is not a threat to himself or others, or more specifically, when the person is not a threat to others, should we as police officers, you as police officers, respond to these calls? Understand that if you do, and you have to detain the person, you have to be very careful, because if the person files a civil rights lawsuit against you, at least in the Ninth Circuit, which is our circuit, you may not be given the same privileges and protections as others, and you might not get qualified immunity. As always, thank you for listening. I hope you give some thought to some of the things that we've discussed. It's one person's opinion, but I'm here not for the citizens. I'm not here for the department. I'm here to help protect your rights. Contact me, droger@lvppa.com, and please stay safe.
111, 110.